Let's go over the obligations of importers under the European Accessibility Act. And so on the screen with me, we have the directive itself. We're looking at Article 9, Obligations of Importers. We can see that there are 9 paragraphs, but we're actually going to use the accessible.org blog post for these obligations. And that is because for each directive, on this blog post, we have a plain English explanation of what the obligation is getting at. And I will link to this blog post in the description. But for now, let's go ahead and define what an importer is under the EAA. So per Article 3, paragraph 19, importer means any natural or legal person established within the Union who places a product from a third country on the Union market. So that is who this section applies to. All right, so let's go ahead and start with obligation 1. Importers shall only place compliant products on the market. That is self-explanatory. Moving to obligation 2. Before placing a product on the market, importers shall ensure that the conformity assessment procedure set out in Annex 4 has been carried out by the manufacturer. So just note that for any annex reference, that's going to be at the bottom of the directive, and there's a conformity assessment procedure, and the importer has to make sure that that procedure has been carried out by the product manufacturer. Continuing on, they shall ensure that the manufacturer has drawn up the technical documentation required by the annex, that the product bears the CE marking and is accompanied by the required documents, and that the manufacturer has complied with the requirements set out in 2 different articles. All right, so continuing on with obligation 3, where an importer considers or has reason to believe that a product is not in conformity with the applicable accessibility requirements of this directive, the importer shall not place the product on the market until it has been brought into conformity. Furthermore, where the product does not comply with the applicable accessibility requirements, the importer shall inform not only the manufacturer, but also the market surveillance authorities to this effect. So here we have the European Accessibility Act having the importer act as a check to make sure that there aren't products that aren't in conformity with these requirements that are being placed inside the European Union. So this is really the surveillance authorities using these different economic operators. And when I say economic operators, here it's importers. In a previous video, it was distributors. And then, of course, it can also include the product manufacturers as well as the service providers. But we have these different economic operators. And here, what the surveillance authorities are, they're really the European Accessibility Act is helping the surveillance authorities to check and see if there are any products that aren't meeting the requirements. All right, so moving on to obligation 4, importers shall indicate their name, registered trade name, or registered trademark and the address at which they can be contacted on the product, or where that is not possible, on its packaging or in a document accompanying the product. The contact details shall be in a language easily understood by end users and market surveillance authorities. So this is getting at, we need to know if a product that comes in is not in conformity with these technical requirements. We need to know who the importer was that placed this product in the European Union. So here we have this information. We're making sure that this information is clear and available. And one other note here, when we talk about obligations, there are obligations for each of the economic operators that I've named under the European Accessibility Act. But this section is not going to be the technical requirements. Think of obligations more as administrative work and paperwork. So if you have that in your mind when you think about obligations, it's going to help you understand what the difference between obligations and requirements are, and then also just keep everything straight. All right, so let's move on to paragraph 5. Importers shall ensure that the product is accompanied by instructions and safety information in a language which can be easily understood by consumers and other end users as determined by the member state concerned. So one thing to remember about the European Accessibility Act is it's a directive, and it's legally not binding, it's legally binding. But the member states have discretion in how they reach these objectives. So think of the EAA as a rule book, and the rule book sets out the instructions and the objectives, but the member states can determine how to carry out these objectives. And so here you have the member states with the discretion and the flexibility to determine how importers shall ensure that the product is accompanied by instructions and safety information in a way that can easily be understood. But that's the overall obligation here. Okay, and obligation 6. Importers shall ensure that while a product is under their responsibility, storage or transport conditions do not jeopardize its compliance with the applicable accessibility requirements. So here, just making sure that you're not, let's just take the example of we have a service that a shipping parcel service, and they have these boxes that they are delivering to the consumer, and they throw the boxes around and they damage the product in transit. And so here in applying the EAA, as part of that damage, the accessibility provisions that have taken place are undermined and the product may no longer be accessible. Well, then the importers would not be ensuring that that they're not jeopardizing the accessibility of the product. And so that's what this is getting at. Importers just need to make sure that nothing happens while the product is in their possession or their storage or transport under their responsibility, etc., where the accessibility is compromised. All right, paragraph obligation 7. Importers shall, for a period of 5 years, keep a copy of the EU Declaration of Conformity at the disposal of the market surveillance authorities and shall ensure that the technical documentation can be made available to those authorities upon request. So remember, I talked about administrative work and paperwork. Here we have that coming up directly with obligation 7. Obligation 8. Importers who consider or have reason to believe that a product which they have placed on the market is not in conformity with this directive shall immediately take corrective measures necessary to bring that product into conformity or, if appropriate, to withdraw it. Furthermore, where the product does not comply with the applicable accessibility requirements, importers shall immediately inform the competent national authorities of the member states in which they made the product available to that effect, giving details in particular of the non-compliance and any corrective measures taken. In such cases, importers shall keep a register of products which do not comply with the applicable accessibility requirements and of the related complaints. So here's another example of where the member state's discretion comes into play, because you might be thinking, well, how do the importers know when they have reason to believe that a product may or may not be in compliance with these requirements that are set out in the EAA? So that's where the member state would come in and decide how that's carried out. But the end effect here is we want to make sure that if there are any products that the importers have reason to believe that are not in conformity, that they take corrective measures to bring the product in conformity, or if appropriate, withdraw it, and then also alert the surveillance authorities. So that's what obligation 8 is getting at. And then finally, we're at obligation 9. Importers shall, further to a reasoned request from a competent national authority, provide it with all the language and documentation necessary to demonstrate the conformity of a product in a language which can be easily understood by that authority. They shall cooperate with that authority at its request on any action to taken to eliminate the non-compliance with the applicable accessibility requirements of products which they have placed on the market. So we've gone through these requirements, and I'm going to link to this blog post in the description so you can read through this. But the important part here is you can see that importers, as economic operators within the European Union, have an important place within the EAA compliance, right? So they're acting as checks to make sure that we're ensuring products that are not compliant do not enter the European Union. So this is an important role that they play within the European Accessibility Act. They're really helping the authorities and the authorities within the different member states work to ensure that compliance requirements and obligations have been met. So this is all a part of the obligations of importers. And in a previous video, I've talked about the obligations of distributors. And of course, we're also going to cover the obligations of product manufacturers and service providers. And remember, obligations are distinct from requirements, right? So even though you think of the two words sometimes interchangeably, no, remember the obligations are more paperwork and administrative, and then there are requirements that are more technical requirements, and then there are also going to be obligations on the part of product manufacturers and service providers. So I will link to this in the description, and if you have any questions or need help with EAA compliance, feel free to reach out to me. I will include more information about accessible.org services as well as a link to contact me directly.